if you unreasonably keep two people in a bad marriage, then, my lord, I'm sorry, the law is liable to be declared bad in law. That is why it's important to understand what exactly are we dealing with. We are dealing with intimate relationships. An intimate relationship, no degree of the court can force an intimate relationship. That I'm only arguing that you must keep that in mind. Right. Well, I've got a few additional submissions. I'll finish quickly before we close for lunch. But they're already in writing. I've given a volume, and I won't take you through the literature on the subject, but there is literature. And the primary additional submission, just tell us. And those additions. The primary one is, Lord, I'm just adding one more submission, and that is the right to marry a person of your choice is a fundamental right and guaranteed under 19(1)(c), read with Article 21. Equally, is the right to divorce must be considered a fundamental right, and no unreasonable restrictions can be put on it. It is submitted that the right should be protected under 19(1)(c). It is submitted that the right of association includes two rights: the right to form expressive associations, such as unions, and the right to form intimate associations, such as marriage and familial bonds. Then, there is this judgment of the Supreme Court in Roberts, which was a very interesting judgment. A club said we'll keep out women. And the law that was passed said that you can't keep out women. And in that case, they distinguished between intimate relationships and non-intimate relationships. So they said, all right, we can force somebody to become to take a woman as a member in a club, because it's not an intimate association, but intimate associations stand on a different level. So only for that distinction between the two associations, the case is known as Roberts. It's there in the compilation.
Yes, page 40. You've given it a note on it and para 2 of your editions.
Para 2.
You already incorporated it.
That is on the well-traveled ground, well-traversed ground by this court on Puttaswamy. I'm sorry. Yes, Malone, there that the summary of Roberts submitted the United States Supreme Court in Roberts, where the constitutional validity of public accommodation laws was under challenge, held that the guarantee in the 14th Amendment of the United States Constitution protected, among other things, the right to marriage, childbirth, cohabitation, and with one's relatives. Such a right would also entail the freedom to leave such intimate association. This, I suppose, is my submission. This submitted that the right to form intimate association is a part of the freedom of association at 19(1)(c) of the Constitution of India. The right to enter into association has an analogous right to leave in such an association without state interference. Now, Milord, this should be modified without, there is state interference in the form of the judge. The judiciary. So therefore, Milord, I would modify it and say reasonable restrictions can be imposed on the right, but not unreasonable restrictions, Milord. And to deny a divorce on the ground of irretrievable breakdown would amount to an unreasonable restriction than the right to leave a bad marriage. Then, Milord, your Lordship may go through Roberts, the full text. I point that in this volume is also literature about how bad marriages impact children. That your Lordship will find.
Yes, page 30.
At page
31.
And how bad marriages are also bad for the two parties in question. There is an article on that as well. I mean, to me, it's common sense, but then academics want research, and that's why I've given you the research.
Thank you.
Lord, I'm here in my capacity as amicus, and therefore I can only persuade you. Beyond that, Lord, there's nothing I can do because I'm not representing a client.
Doesn't make a difference.
But
you are still persuasive enough.
I have to say that your Lordship have given me the liberty to express my point of view, but in my capacity as amicus.
Thank you.
Well, Lord, there's no judgment of this court, incidentally, on what is the goal of an amicus. I haven't seen it. I've been looking for it high and low.
In one sentence, to make us write better. Mr. Girish, you'll begin at 2 o'clock?
Yes.
Obliged for application.
After Mr. Girish finishes, I'll take about 45 minutes.
Okay. How much time will you take?
Not more than 40 minutes.
Let's try to wind up today.
Very
because
I'll convince myself.
I've scheduled other constitution benches immediately after reopening. So I would like to, I anticipated only about kept 1 day's cushion.
I would read from the judgments, my lord, for the compiled.
Objects would give us some time also.
On what? See, divide your time. Both are saying. Ultimately, it will be repetition otherwise.
Correct, we'll not repeat.
All of you seem to be, I have not heard a different point of view. All of you seem to be on this basis that in different ways, please
Yes.
exercise this power.
Yes.
But I am going to be respectfully
Oppose.
submitting to the point.
Oh,
The lordships cannot exercise.
Oh,
No, no.
I'm glad my learned friend mentioned that.
no, it's at least that somebody puts a different point of view. Somebody has to put a different point of view, so we have the satisfaction of.
Really, because the way 142 has been used by this court, it's matter of.
No,
concern.
the loose copy.
From income tax, for all kinds of matters, 142 is now being exercised, and that's a matter of great concern.
Probably on the argument about fundamental right to association and then fundamental right to get divorced, we may not be agreeable with the submission, you know. But on the question framed, not we would argue that yet, yes, it can be exercised, it can be molded, it can be read into the enactment. Will be our submission.
If Mr. Dave,
One,
I try to wind up, my lord, in 30, 35
if you
minutes.
can wind up in 30,
I'll just
35
make the
minutes.
points
And
for-
similarly, Mr. Dave, if you can make an endeavor to conclude.
It's next.
I won't take.
I'm trying to persuade you to take 10 minutes less so that the others get it done.
I should have mentioned, just give me 2 minutes, below, delay your lunch by just 2 seconds. At 2019, page 1, just make a note of the judge. It is a case where the issue was whether voice sampling can be done.
Yes.
And one of the arguments was that this would go against the right to self-incrimination. The court rejected it. But what is important in support of my argument that it can be done under 151 is, my lord, that this court actually said we can give this power to the court, to the magistrate court, para 22. That was done. So far as the second basis of the view taken is concerned, we have already expressed our opinion that what may appear to be legislative inaction, very important, but not in the light of Mr. Dave's submission. To find, no, because he's. I know you're right. Yes, I'm glad there's a contrary point of view because I can counter it. Well, I said, because I'm not holding a.
Just give a note.
Yeah, let's speak.
Serious inroad on Article 20. And it's completely conflict.
Okay, thank you.
Well, I can tell you
I
many
have a-
judgments in this court,
all I can say
but they're judgments of the court.
You're not depriving us for lunch.
You don't tell me what to rely on, okay? What to rely on and what not to rely on. It's not your remit in this court.
Something apart from depriving us of urgent lunch, I have a meeting also of some concern to lawyers. We will sort out that problem.
So, just, your lordship will look at this judgment where, there's an interesting discussion on whether this is
We'll
legislation
read
or
through
not
the-
legislation.
We will read through the interest.
Yes,
Thank you.
Please do because it can be done.
Thank you.